Mille Mágad the Cancórla, and I welcome the opportunity to speak on this bill, Supports for Survivors of Residential Institutional Abuse Bill 2024. 21 sections, 4 parts, no regulatory impact analysis, no explanation given for that, and it's based the pre-legislative scrutiny, did a detailed report, gave a detailed background, had 10 key recommendations in addition to other recommendations, and I understand all 10 have been completely ignored. And we have a minister who's made a speech who talks about the importance of listening to survivors, and we all should do that, but acting on that, what we heard, has gone by the board, Minister. Now, I've taken a particular interest in this topic for many reasons, both professional and personal, since the day I was elected. And I have to say, I'm not given to despair, but it is extremely difficult to watch each piece of legislation and each scheme perpetuating the abuse for the survivors. So we have here a scheme ostensibly to finish or complete Cara Nua, new friend, which I'm on record for saying was anything but a new friend, but was the old enemy on Sean Norwood in disguise, and now we abuse language to call it the new friend. And that Cara Nua finished accepting applications back in December 2020, standard applications. Here we are, almost 4 years later, putting through a piece of legislation to wind up Cara Nua that stopped providing payments back on the 11th of December 2020 and ceased as an operational entity on the 24th of March. It received 6,181 applications and made out over 57,000 funding support payments. Now, why do I mention that? I mention it because a huge section of this bill is to deal with Cara Nua. And I find, and I'm told, that there are people still out waiting for their case to be finished. So, Minister, today you might tell me, I only know one that's been highlighted with me. Are there other people, applicants, in that position still? And that Cara Nua, which I'll come back to later, but for the moment to say that, to me, was maladministered. I use that word. And prior to that, we had the Magdalene scheme, which was maladministered. And those words were used by the Ombudsman. And he called it an opportunity lost. That was his report. An investigation by the Ombudsman into the administration of the Magdalene Restorative Scheme. Peter Tyndall, November 2017. What did he say? I therefore find the manner in which the scheme was administered by the department constitutes maladministration. And there are 2 pages here of where he goes through it all, pointing out which parts were maladministered. You would imagine that we would learn from that. We had the McAleese report where the truth was dragged out in the end that the state was absolutely involved in their non-action and indeed no supervision, and actually sending clothes to be washed from the various state organisations and so on. And then we set up this scheme, and then we have to have Justice Quirk tell us how to do it properly and how to be inclusive, all ignored, of course. He talked about such things as an amendment, the special medical card, not the enhanced medical card, but the Health Amendment Act card that was given to people with haemophilia. And he asked for that as one of the things to be given. Here's Peter Tyndall's report. It's worth reading. And then let's look at what led to this a quarter of a century after the former Taoiseach apologised to us, quarter of a century, to say that the people in these institutions, the young children, weren't to blame. And we look at that and we see what has happened since then. And I'll just give you a quick look at the redress board that was set up following that apology. And at the same time, the Ryan investigation became known as the Ryan report, set in parallel with the redress board. That redress board accepted applications from residents of 139 reformatories, industrial schools and other relevant institutions. Listen to those figures. You know, this was a country of incarceration, but for the poor people, for those without power. And that functioned up to 2011 and got an extension of time. And 15,579 people applied. And in this new scheme that we're doing now, we're making it a condition precedent that they had to come before that board. Isn't that right? Or had to get a court award. Otherwise, they can't avail of the supports that are coming in this bill, the limited supports for some people. Can you imagine? We now have another divisive scheme that excludes people all over again. We spent a century doing that in the reformatory and industrial schools, the mother and baby homes, and all of the institutions, and now we copper fasten it on each scheme that we bring in. Now, there was one good example that I'll come back to directly from the Department of Education, which seems to have got good praise, which we've completely ignored. Now, in relation to this scheme, you know what we did to survivors? And I have to say, I have to declare a conflict of interest because I was there in a previous life. And if I disclose anything in relation to the clients that I was with, I will still be committing an offence. More importantly and more relevantly, the people that went before the redress board, if they declared what they got, they'd be committing an offence. So they were sworn to secrecy. Now, Ken Corla, I'm not sure if we're aware of this, but this is what happened. This is the legislation that was brought in. Gagging orders. Couldn't say. And what was their direct experience of that? And I was part of that. I earned money from that. I went up as a professional. And they talked about being re-traumatised with the cross-examination. They talked about the re-trauma of the religious orders, males and females, writing in letters that were read out to that redress board. Nobody present, but the letter assumed great importance because it came from the religious organisations. And fast forward to the mother and baby home, again, the same type of importance being put on the evidence from professionals and religious, while the survivors was the warning contaminated evidence. So this is where all this started. And that legislation is still intact. So we were, in fact, re-traumatising them, attempting to recriminalise them, because remember, some people had been committed by court for doing nothing other than being poor. And that's what happened. That was that redress scheme. And now we're building that into this to say you had to apply to that in the first place before you can do this. Sometimes I'm lost for words with this because I wonder at what stage will we learn. And the Star just lately brought it into acute focus for me, the absolute class distinction in this country that's never talked about. And so what happened with the Star just wouldn't have happened with any other group that didn't live in that area. And similarly, the thousands that went through our schools are being re-traumatised at every step of the way. And so we have a mother and baby home that's been referred to in the documents that I've read, and the Magdalene scheme, as examples that justify what we're doing here. So we're not going to give the Health Amendment Act health card, which gives admission to more services. We're doing what we did with the Magdalene, and we're doing what we did with the mother and baby home scheme that's in process of being rolled out. And then you say, but that's completely discriminatory. That is utterly wrong. Why are we now doing the exact same thing that we know is wrong? And Minister, I really would like if you, as the new Minister, would really leave your script at the end of this and try and address it, because I do not wish to be confrontational or argumentative. I'm too tired for it, actually. And I despair that we keep doing the same bad things in the guise of the patriarchal, patronising system. This is good for you, when we know well it's very bad for you. And who are we talking about here? Well, there's any amount of research that tells us that survivors are poorer, doing less well, intergenerational trauma, and of course this scheme is not going to help the family of survivors. It's not going to help the children or the grandchildren, even though the trauma is intergenerational. Over and over. Other schemes did. And I referred directly to the Educational Finance Board, which seems to have got great praise from the survivors, directly run from the Department of Education. And when praise is due, it's due. And it responded to the needs of the survivors who came forward. And that's in their words. And what do we do with that? We ignore the good example and we follow all the bad examples. And just in case that anyone thinks that I'm given to exaggeration, let me just look. Ryan's report, an outdated system, this is the Ryan report, on the industrial schools and the reformatory schools, a fundamentally flawed system of inspection, Department of Education's deferential and submissive attitude towards the religious congregations compromised its ability to fulfil its statutory duty of inspection. Systemic use of corporal punishment, a climate of fear created by pervasive, excessive and arbitrary punishment permeated most institutions and all of those run for boys. Endemic sexual abuse in boys' institutions and predatory sexual abuse against girls. Sexual abuse was endemic in boys' institutions. It was not systemic in girls, but girls were subjected to predatory sexual abuse by male employees, visitors, and in outside placements, and so on and so on. A system completely out of control, run by the abusers, unmonitored by the government, unsupervised by the government, and hence the redress board was set up, and then we gagged them, and we stopped them, and we re-traumatised them, and we're still doing it. Then we look at the pre-legislative scrutiny, and there were, as I said, 10 key recommendations, and every single one of them ignored. And I have a little time, so I'm going to go through them. Legislation should apply to all survivors, regardless of whether or not they received a award or a settlement. Not accepted. Not accepted. Will only provide those two situations which many of us have mentioned. Recommendation 2, all survivors should receive a health amendment, a health HAA card. Not accepted by the Minister. Survivors of institutions living abroad and so on should be eligible. Survivors of institutions living abroad and spent time in Magdalene institutions and received a payment under the redress should be eligible. Not accepted. The proposed 3,000 once-off payment, insufficient, ignored. The Department of Education should liaise with the UK's Department of Work to ensure that anyone who gets that small amount of money, it shouldn't affect their entitlements. That was left open, and I think there will be some negotiation. It wasn't quite rejected, not quite accepted, because the last line said England will do what England will do. Legislation should ensure that survivors are not re-institutionalised. Therefore, HA cards should provide for home nursing and home care services. Not included. Educational support should be for survivors and their families, not excluded. Not accepted. Provide for the establishment of a professional advocacy service as a statutory body, not accepted. The interdepartmental government committee should be reconvened as an urgent priority, not accepted. Provision for a state pension for all survivors, not accepted. Okay? Now, I've gone through it. I've gone through the whole lot. None of them accepted. So that lovely speech from the Minister that said we must listen and learn has turned language once again on its head. We must listen and ignore. We'll continue on with the divisive discriminatory policy, and we will treat them as them out there somewhere, nothing to do with us or the governments that allowed this to happen. And I'm here today again, and I'm repeating, and I hate repetition, actually. I just can't believe what continues to happen. And I wonder at what stage will the females in the government and the three parties actually come in and speak up for women, as well as the men, of course. At what stage? I think I saw one backbencher coming in between yesterday and today. Where are they? How can one single female TD or minister stand over the fact that we're going to exclude thousands of people from the mother and baby home because they're under 6 months, less than 6 months spent? And I have, tongue-in-cheek, said to Deputy Sherlock with his new baby that he wasted 6 months of his life caring for that baby. Because according to the minister and the government's policy, you don't need to look after a baby at all. You can let it scream for 6 months. It doesn't affect them at all. They're a tabula rasa. They hear nothing, they do nothing. That's the mother and baby home scheme. And the religious orders were let off the hook completely in 2002 by Minister Woods, who settled for 128 million and gave an indemnity. 128 million and given an indemnity. And some of that money was then used for the Department of Education, which did very well in giving out grants. And then the next thing was Carranua with 105 million. I sat on the Public Accounts Committee and I watched with despair when the CEO of that Carranua came before us. I won't mention names here. I watched with despair and disgust in the manner that survivors were referred to by that paid official. I saw more chairs of that board going through a revolving door. I saw more staff, agency staff, being brought in with very little training, a few months and gone, and they were assigned as key workers to the survivors who came before us. And I thought, what's happening here? Where is this money? What's happening with this money? And I realised that 128 million was given, a drop in the ocean, in 2002. And then the religious orders were struck not by guilt but by the forcefulness of the Ryan report in 2009, so they voluntarily came forward with a bit more. So every scheme that we bring in is ad hoc and reactionary in relation to the amount of money coming forward and available from the religious orders. And once again, for the record, I'm not here to castigate religious orders, but I'm here to castigate what they did in the institutions throughout this country. And yes, they should be responsible, and yes, they should pay. And just yesterday, I asked for an update from the Minister in relation to the negotiations for the mother and baby, for the religious orders, what money they were now going to give, 18 orders. He doesn't know because it's confidential. It was to be done in 6 months, but an extension of time was given. Absolute kid gloves, absolute respect and dignity being given to this process to negotiate with the religious orders who were in charge of all of this abuse. And maybe that's what we've learned, that we should treat people with respect. But we're doing the complete opposite with survivors. We're treating them with utter disrespect. We're looking down on them in the same manner that we have done for the whole history, century and a half of institutionalisations. So forgive me if I'm hot under the collar in relation to this scheme. And if the government had any sense, they would stop. They would simply stop this. You set up a consultative forum, you set up a consultation process, you had people do research to tell us how vulnerable residents were on an intergenerational basis, and then you ignored it all, and you leave us with no choice but to say, I cannot support this. This is an appalling piece of legislation in the guise of saying we're now helping you again, but we'll help only that small group that were in that group of institutions who applied previously to a redress board that they found traumatic or went to the court and found equally traumatic, and we'll ignore all the others, the children that were boarded out from the mother and baby home, the children that spent less than 6 months, and all the other institutions that have been recognised. For God's sake, please, for God's sake, at what stage will we learn? Garamagat.